of the rule of law and Article 133, subsection 1 of the Constitution of Ghana, any decision by the Supreme Court can only be reviewed and varied by the Supreme Court itself. In this regard, individuals, judicial and non-judicial bodies, including independent constitutional bodies and the various arms of government, are all bound unconditionally by the decisions of the Supreme Court. In case where any party in the categories referred to above is aggrieved by the decisions of the Supreme Court, the only recourse available to such a party is to apply to the Supreme Court for a review of its decisions. In light of the above, Parliament will be in breach of the law if it refuses to accept the ruling of the Supreme Court. Even if Parliament is of the view that the decision of the Supreme Court is wrong, it must comply first with the orders of the court and adopt a judicial path to the resolution of the matter. Against this background, Parliament took the right step, albeit belatedly, in filing an application for the review of the Supreme Court's decision. However, it is my considered and respectful opinion that the course of action and the associated remedies endorsed on the writ of application of Parliament is unmeritorious and lacks judicial grounding. By arguing that the decision of the Supreme Court cannot affect a non-judicial order of Parliament is a subversion of the rule of law and abuse of judicial process. For the avoidance of doubt, all individuals, legal personalities, judicial and non-judicial bodies, independent constitutional bodies, and the various arms of government are bound stricto sensu by the decisions of the Supreme Court. As indicated earlier, any aggrieved individuals or bodies as referred to above can only apply to the same Supreme Court for a review of its decisions. The claim by Parliament that it is a master of its own rules has no merit in law and seeks to undermine the very spirit underpinning the concept of checks and balances between the various arms of government. In light of all of the above, the Speaker of Parliament is right to declare the 4 seats vacant and issue a consequential order for the minority caucus in Parliament to be considered as the majority caucus in Parliament. This order, however, can only be made, and I want to emphasize this order, however, can only be made by the Speaker of Parliament if and only if the Supreme Court makes a ruling in favor of Parliament in the determination of the substantive case currently before it. Ladies and gentlemen, with barely 4 weeks to the general elections, it is absolutely critical that all parties, that is the judiciary, the legislature, the executive, and indeed the citizenry of Ghana, work towards a resolution of this delicate matter to ensure a peaceful path towards the 2024 general elections in December. I thank you for your kind attention.